Okay, I believe we are live. What's going on, YouTube? RDAPDAN here, Federal Prison Time Consulting. Hope you guys had an amazing new year. Welcome back. And mute this. So this. Oh, geez, we got all kinds of sound going on. I'm not even sure where this is streaming at right now. Hold on a second. Apologize, guys. It was kind of streaming everywhere. So as you can see, we've got a guest with us today. We've got Tom Root, who is an expert on prison reform topics. He's actually got a couple of different things going on here. So before we get too off on talking about the First Step Act, make sure, if you guys haven't already done so, in the description of this video, you can actually check out Tom's website, which is lisa-legalinfo.com. And I will make sure I post that into the comments here in a few minutes, but it is in the description of this video. So Tom, tell us a little bit about yourself and welcome. Appreciate you giving us this opportunity.
Thanks. Well, let's see. I attended Ohio State University College of Law. Sorry for you people in Washington State, but played hell of a fourth quarter. I will give you that. Graduated in 1977, practiced telecommunications in a federal agency for a period of time, then morphed into more general practice, doing a lot of corporate work. Ran afoul of the U.S. Attorney in the Eastern District of Pennsylvania, and ended up, so I've been on both sides, just like I think you have, Dan. Now I spend my time, well, I write about tree law, which is of interest to none of you, and do an awful lot of work on federal post-conviction and criminal appellate matters. I write a newsletter. I've got about 6,000 guys in the system who are subscribers now. It goes out every week. I try to focus a lot on legislation because one thing I noticed when I was there is we'd always hear that a bill was introduced and people would dance in the hallways and nothing ever came of it. No one ever knew what happened. So I try to follow the legislation, the Sentencing Commission, do a lot of Supreme Court following. Have a good time doing it, and I hope I'm giving them some value.
I mean, I think you are, from what I've read, and I came across you about a week ago, and you and I had a couple of conversations over the phone. I think it's real important people to understand, for those of you that are just tuning in. So Tom, he was a corporate attorney who ended up, like so many of us, had to go off and spend some time in federal prison for a while. This was quite a while ago. And you've been out how long now, Tom?
5 years. 5
years. So you've been out for 5 years and you're off. Are you still on supervised release or are you off of?
No, I'm done with that so I can talk to anybody.
Free and clear.
And don't get me started on supervised release. That's a whole different topic and something that I have a lively interest in.
We'll save that for another video because I'm sure you've got some interesting topics for that. But today we're going to be focusing on the First Step Act. And I'll tell you, obviously the bill's passed and I'm getting flooded with emails, phone calls, text messages. When is it going to kick in? Which parts of it are retroactive? Who's it going to apply to? Who's it not going to apply to? And that's when I came across your email, because even just today alone, I called and got a hold of Grand Prairie, Texas, and the guy had no clue as to when any of this was actually going to be implemented. And I imagine now with the feds on the shutdown, I imagine that's throwing additional wrenches into things. So we've got a list of questions here. And Tom, you are an expert in prison reform, specifically on the First Step Act. So I'm hoping we can give people some information. I'm sure it's not all going to be peaches. There's probably going to be some information here people probably aren't going to like to hear, but it's better to get it directly from you versus hearsay on inmate.com. So if you're ready, Tom, I'm going to go ahead and ask you my first question here.
Let's go ahead and do it.
Okay. All right. So first question, these are questions, guys, that we sent all of you emails, people within the prison system. What questions do you guys have to make sure we can kind of sum it all up to give you guys what you're looking for here? So the first question I have out of 20 is, does this bill get us more halfway house time? And does that mean we go straight to home confinement, not to a halfway house?
Well, we can parse that into several sub questions. Let me take the first one. You know, now you're entitled to up to 12 months halfway house under the Second Chance Act. And those few of you who are lucky enough to get it, my hat's off to you. You're entitled to 6 months maximum, or 10% of your sentence on home confinement. There's only one way to do better than that. The First Step Act says that those time limitations do not qualify if you get program credits. I better go back to that. You know, the heart of First Step is that Congress wants to reduce recidivism. And it's going to reduce recidivism by having people take evidence-tested courses and engage in activities that reduce recidivism. Everyone wants to know what those are. Well, nobody's sure yet. I have my suspicions. I think that probably working in Unicor, especially if you're on the shop floor, is going to count as a program that reduces recidivism. I think, I'm just about sure GED will. Whether ACE classes will, I don't know, but Senator Langford from Oklahoma got some language put in the act about faith-based organizations participating. So I think they're going to be very expansive in what these programs are. So you take the programs, and for every 30 days you're in a program that you ultimately complete successfully, you'll get 10 days of program credits. In fact, if you are a low risk person or a minimum risk person, you can get 15 days a month. So you build this time up, and what does it get you? The Act says you get one of three things. You get more home confinement, you get more halfway house, or if you have supervised release after your imprisonment ends, which virtually everybody does, you can get cut loose early, cut loose from the sentence on to supervised release. Now, a lot of questions about what the fine points of that, but let's just take halfway house time and home confinement. Can you get more? Yeah, only through the programming. You can get as much as they will give you. The time limits of 12 months under the Second Chance Act for halfway house and 6 months for home confinement do not count if you earn program credits. That's the good news. Now, the bad news is you don't know what you're going to get. It's up to the BOP to decide whether you get home confinement, whether you get halfway house, or whether you get time off your sentence. But they can only give you 12 months off your sentence. So you're a guy who programs for 4 or 5 years and you program hard every month, you got 720 good time days under programming. You can only get a year, half of that, in a reduced sentence. The other half can be awarded as halfway house or home confinement, but you're never going to take more than 12 months off your sentence.
So even with this bill in place, still, no matter what, the most you can get off your sentence, not counting RDAP, is 12 months of the combination of halfway house, home confinement.
No, I'm sorry. Maybe I wasn't clear. You can get 12 months lopped off your sentence, just like RDAP. So if you got a 10-year sentence, you can go to supervised release after 9 years. You'd only serve 9 years of it. And if you do a lot of programming, your last year, year 8 to 9, may be halfway house, maybe home confinement. So you could pick up a year halfway house, you could pick up another year of home confinement, and you could pick up a year off your sentence. Of course, that means you programmed like a banshee for a decade, but nothing's going to stop you from doing that. So it's not a limit of 1 year of everything. It's just 1 year off your sentence. Beyond that, you can get halfway house, you can get home confinement. Because when I say those, halfway house and home confinement, you're still in BOP custody. So right. You're still doing your sentence. You're just doing it someplace other than in prison. And like I told a guy today, he said, have a home confinement. I got to sit there. And I said, let me tell you, my worst day of home confinement beat my best day in prison.
Very, very true. So from your understanding, Tom, as far as what's going to be retroactive, I know that the 54 days giving the additional good time off of your sentence, I know that they're planning on that being retroactive. Are any of these other programs, like right now, they haven't decided what programs are going to constitute for the 10%. I mean, the 10 days per month. once they do decide, are they going to make that retroactive for programs? Like, let's say it was Unicor, people that are already in Unicor, are they going to get time starting now or from time when they implement what those classes are?
Well, there is a provision buried in the bill that says the effective date of the programming is the date the Attorney General sets up risk assessment procedures. The way this thing's supposed to work, is the Attorney General sets up a whole risk assessment system. He may look at you, Dan, and say, yeah, you're a minimal risk guy. He may look at me and say, oh, hell, you were a lawyer, you're high risk. Whatever they use on the scale, we're going to be high risk, medium risk, low, or minimal. And once that risk assessment system is in place, even though the programs haven't been identified yet, if you take something that ultimately works, you could get credit. Now, the Attorney General under the Act has 210 days, and I figure that comes to about July 20th, something like that. So by July 20th, under the statute, he's got to have that risk assessment system in place, and there's no waiver, there's no extension. He can't file with the court and get more time because the statute says 210 days. So starting July 20th, whatever you're doing, you might get, or you could get credit after that. Now, catch is the First Step Act says the BOP may, at its discretion, award you time for that period after July 20th when they're still trying to figure out what's going to count. They've got 180 days after July 20th. So everything has to count effective about January 20 of 2020. But it could start counting as early as next summer. If the BOP acts rationally, they'll start counting it next summer because, it cuts down on their population. It cuts down on their load. For the same reason, I think if the BOP is rational, it will award as much time off the sentence as possible because all that time off the sentence, your sentence doesn't cost them anything. Once you're off the sentence and you're being supervised, that comes out of the probation office budget.
Right.
But is the BOP going to act rationally? Have we seen the BOP act rationally? I'll let your listeners answer that.
Not so much.
Yeah, I still have hope though that the BOP is in such a budget hole, it will want to take the route of least resistance, which would be first cutting your sentence, second giving you home confinement. I think the numbers are on home confinement are something like $8 a day for home confinement, $70 a day for halfway house. So, which one would you choose?
Right. So I think you answered actually a couple of these questions already. So just to be clear, what is the maximum time of house arrest, home confinement that can be accrued? So you're saying 12 months, correct? That doesn't change.
No, 12 months. You can get 12 months off your sentence, just like RDAP can cut 12 months off your sentence. You can get as much halfway house and home confinement as they can give you.
Okay. What's the most you've ever seen them get? Not sentenced to, but what's the most once you've seen somebody in the Bureau of Prisons incarcerated behind the fence? What's the most you've seen them send somebody home on?
You mean halfway house?
Yeah, halfway house or home confinement to finish out part of their sentence. What's the most you've seen them give out?
Oh, that's a funny thing. You know how so many guys will say, well, down at, and then fill in the blank of some other prison. Had a guy tell me, yeah, I want to transfer down to Jessup because Jessup's giving everyone 12 months. I talked to guys in Jessup and they said, oh, no, man, we want to go up to Elkton. We're getting 12 months up there. Well, everybody knows somebody who got 12 months of halfway house. I don't. I did actually know one guy who got 10 months. And then as far as home confinement, I've seen a few guys get their full 10%, 6 months.
I was given 11 months halfway house.
Oh, now I know a guy who got 11 months. Okay.
And that was in addition to my year off for RDAP.
Yeah.
And I was very fortunate. I got the full 10% home confinement as well. So
okay. You went for 11 months to halfway house. After 5 months, halfway house sent you home?
Correct.
Yeah.
Yep. So it's still just a total of 11 months combination, halfway house, home confinement.
Yeah.
I've personally never seen anybody get more than 12 months halfway house, and then a portion of that, depending on how long their sentence was, 10% of that done on home confinement. But I've never seen anybody receive more than 12 months combined of halfway house and home confinement. Will this bill possibly improve for people to at least be given 12 months combination, halfway house, home confinement, if they follow the guidelines and program whatever the programs are going to be.
Yeah, this bill leaves it wide open. It mandates that those time limits, the 10% for home confinement and the 12 months halfway house, those time limits do not count if you earn program credits. It's, the field's wide open. As many credits as you can get, that's how much time the BOP's got to give you. They've got to give it to you someplace. Now,
So the BOP technically could give somebody 13, 14 months of halfway house, combination halfway house, home confinement through program credits.
Yes. Yeah, they could. And the halfway house could send these people home right away on home confinement because they would not be constrained by any 10% limitation.
So this removes the 10% restraint as well.
Yeah. Yep. Those two sections of 3624 do not count if you're doing something with program credits. Now, if I had somebody ask me, because got a lot of guys who don't qualify, and this guy has a 924C, and he said, well, what will I get? Well, those limits are still there. He could still get 12 months halfway house and do his last 10% or up to 6 months in home confinement, but he's not going to get any more.
Right. So we've got a couple of people in the room with us, Tom. Let me see if we have any questions pertaining to this. We got Glenn Glon. Oh, hey, what's up, Glenn? Glenn was actually, he was in prison when I got there. We were in the same pod for quite a while, and he was just telling us that he received 10 months halfway house. And then we also have Jenny Good with us, who is part of our staff, part of our team. Jenny's actually taking notes as you talk, Tom, because she's going to be sending all of your valuable information back to our flooded email system of incarcerated individuals. So Jenny, if you have any questions, maybe Tom's rolling over this stuff too fast for you, or anybody else, if you missed anything, let me give you guys a couple of seconds here to take some notes. So far, what I've gotten from this, which I've already learned something that I did not know, that through this First Step Act, apparently you can be given more than 12 months halfway house, home confinement combination, however that works, based on programming credits. We just don't know what determines programming credits yet. So that's still the missing variable, I'm assuming.
Yeah, and that is.
What would you tell somebody if somebody called you up right now, Tom, and said, hey, Tom, I'm getting ready to go into prison. I know there's not a lot of programs available. I know they're supposed to be rolling out some programs. What would you suggest somebody to start programming, thinking it's going to be lined up with whatever they're going to implement? I know you already said, geez, my mind just went blank. You said
GED, Unicore. Those are good things to do, whether you get credit or not. Of course, they'll force you to do GED, but I'm sure GED is going to count because these programs are supposed to be, there's supposed to be evidence that they cut recidivism. And there's already plenty of evidence that the GED makes a real big difference.
Do you think RDAP will be in there? As far as we know, they already get time off for RDAP, but do you think they'll be able to double dip and also get programming credits?
Well, the Act has a provision that says the BOP is supposed to award the programming credits in addition to other credits people are entitled to. And I took that to be a directive to the BOP that you're not going to say to people, well, yeah, you got a year off for RDAP. We're not going to give you a second year off for this. I've mainly had the RDAP question come up on guys who want to use this Elderly Offender Home Detention Act. Guy said, well, can I do my RDAP and then take that? And I said, well, problem is they always give you the RDAP at the end, usually the last third of your sentence. And, you can't be at home and take it. But the Act does provide that they can't do the bait and switch on you and say, well, you can do RDAP or you can get these program credits, but not both. Looks like you can indeed stack them.
Okay. So then I would imagine if you don't qualify for RDAP, maybe they didn't have enough information in their PSR, whatever the reason is, there's NDAP, the non-residential version of RDAP. I'm going to go on a limb and probably think that's going to be one of the classes that is going to be considered evidence-based just because it's based on cognitive skills. Very easy to measure those type of stats. Do you think that's going to be one of the classes that is going to constitute some of this programming?
Oh, yeah, I absolutely think it will. There used to be, and I don't know if it's still there, there was a life skills program. I think they had it up at Milan and a few other places. And these guys would go up, and it was much more faith-based. They got nothing for it, but guys would go up and take it anyway. I suspect that will be included. I think the BOP is going to scramble to find courses that fit it. I kind of hope the ACE classes fit. Because I took a lot of ACE classes.
Yeah, that would be great, because some of these prisons, actually, we got somebody that just commented in the room, which is kind of on the topic, and then I'll get back to these questions. I'm going to try to keep this this video to around an hour or less. So Jenny or CJ, whoever's watching, or anybody in the room that's got a timer going on this, if you can let me know when we're about 10 minutes out, so I can try to wrap things up. But one of the questions we just got, Tom, was from a gentleman by the name of Lee Weimer. It says, Dan, this is Lee. I'm going to Mercury, a small camp in Kentucky. Will there even be less programs available for credits? What are some examples of programs to look for to sign up for? So I think that kind of talks about what you were just talking about. So Lee's going to be going to a small prison camp. And I get this question all the time, Tom, because some of these prisons have zero programs, like other than maybe a GED class. Some prisons don't even offer that. So do you think we're going to see these prisons that have no programming start implementing programming based on this new bill that passed?
Well, the act says they have to. The BOP is obligated to make the programs available to everybody. So it's going to be real hard for them to not. I suppose what you'll see is quantity. You won't have many. And, you've got a 250 guy camp. It's just not going to have the opportunity you might have at a larger low. But, right. I anticipate that, well, they're going to have to. The BOP, if the BOP can find a loophole, the BOP will find a loophole. So I suspect that some of this will be done grudgingly. Some of it may just be done, it'll be the tip of a hat to the program. But frankly, if your goal is to build the program credits, doesn't much matter. I suspect that those smaller places will end up with a lot of inmate taught ACE courses. I don't know about you, but I took some fantastic ACE courses taught by inmates. So no complaint about that.
Myself included, took quite a few ACE. I was teaching a credit class in there, and they were actually giving inmates credit for taking this class. It was counted towards some of the classes that they were making inmates take. So most of the classes I took that were beneficial were actually taught by some of the smartest individuals I've ever met in my entire life that happen to be inmates. So Lee, to answer your question, looks like, based on the smaller camps, it's going to be hit or miss, but anything that may have to do with Unicor, you're probably going to want to get involved with. If RDAP, obviously, if you can take RDAP, that's going to be a great option. If you can't take RDAP, you can still definitely take the non-residential program, which there's a good possibility that will offer some of these credits. And now it's for every 30 days successfully completed. So if you start a class that's a couple of weeks in and you do not program for 30 days, from my understanding, you get no credit unless you hit the full 30 days, correct?
That's how it reads. And it also sounds as though you take a 3-month course, you're not going to get the credit until you successfully complete it. And then if you did 3 months, you'll end up getting like 30 days, 10 days a month. I also might throw in any of the anger management, life skills, anything the psych department offers. I would expect that is going to very quickly get credit for being recidivism reducing. So look for those courses.
Okay, good information.
Usually you just sit around and talk for an hour. It's kind of touchy-feely. It's not so bad.
We've got a good question. I've got 2 questions here. Jace, I'm going to answer your question in a second because it's a very easy question to answer. Raquel J, this is a great question. I already know the answer, but I'm going to let you answer this, Tom. Raquel J, will all inmates be eligible to earn program credits regardless of offense?
Sadly, no. There is a long list. I think it's now something like 63 exceptions. Now, some of them, if you stole nuclear material from the reactor where you worked, you got problems. That's not going to affect many people. But a 924C, that's a problem.
Explain, elaborate. What is a 924C, Tom?
924C is possession, use, or carrying a firearm during a crime of violence, during in relation to a crime of violence or a drug trafficking offense. The government loves it because it's a mandatory additional 5 years. 5 years if you carried it, 7 years if you showed it to them, and 10 years if you fired it. But there had been a lot of back and forth on it. First, 924s weren't counted. Frankly, I know a lot of guys who got nailed for 924s because when they got arrested, there was a gun in the closet. But you had to satisfy the politicians, and they saw 924 as being, a dangerous crime. I'm not going to say violent because crime of violence is another category. And so the first modification was it was only 924s that had an underlying crime of violence would count against you. By the time Congress got done with it, no 924C is going to get credit. I have a lot of drug guys asking me, all right, and say, hey, can I get credit? I had an 841, which of course is possession with intent to distribute, manufacture. That's the drug offense. The answer is, I don't know unless you tell me more. Congress exempted 3 drugs. If you had meth, if you had heroin, if you had fentanyl in your case, then you will be excluded if you were a manager, a supervisor, a leader, an organizer. That 3B11 enhancement under the guidelines. I had a guy who said, yeah, I had meth. And I looked at it and said, yeah, you were low level. You didn't get the enhancement. You're okay. And
so you can have the drug, but as long as you're not enhanced as like a manager, leadership role, you can still qualify.
Yeah. Then I had the guy write and say, oh, I guess I'm screwed because I had marijuana, but I was leader organizer. Said, nope, all the marijuana you want, you do anything you want with it. That's not exempt. That's the problem. There are a lot of, you got to read it carefully. I had a couple guys who had the porn downloading offenses, and they were excited because they said, it's not even listed there. And I said, well, actually it is. You'll find a provision that says the entire chapter that includes all those offenses.
So any type of sex offense at all?
Yeah, anytime. Essentially, if your sex offense requires that you register after you get out, you're not getting the credits.
Okay. Gotcha.
Now, I've had guys say, then there's no point to taking the courses. Well, actually, maybe there is, because there is another provision that says people enrolled in the courses, unless they're failing out of them, get more and better commissary, get preferential treatment in preferred housing for places that have preferred housing, get higher phone limits, and have first shot at getting a closer to home transfer. So, I worked with a guy who has one of the downloading offenses. He is about 495 miles from home, and under the current BOP regime, that's close enough.
Yeah.
And his parents are old. They don't have any money. They can't travel. And he's got a prison 20 miles up the road. But we haven't been able to get him closer. Now I can say, take those courses, even though they're not going to give any time credit, get you closer to home.
So taking these classes, so additional benefits, taking these classes, additional commissary, additional phone minutes, longer visitations, and possibly better housing units to live in, and transferring closer to home if possible. You've got clients, I've got clients that they call me and they're like, doesn't the BOP have to send me within 500-mile radius? It's like, well, if you live somewhere crazy, like in Hawaii, there's nothing there. There's nothing within a 500-mile radius. So you're forced to go to these different places. I have a feeling, who holds the BOP accountable in enforcing this? Like if the BOP doesn't do it, who cracks the whip?
Well, that you opened a whole new can of worms. The provisions in Title 18 that deal with where you're sent to prison, when you get out, all the prison management. There is one section that says the requirements of the Administrative Procedure Act does not apply to any of those. Well, that's how we hold agencies accountable. You sue them under the Administrative Procedures Act for actions that are arbitrary and capricious or not in accordance with statute. BOP exempts itself from all those. And, well, Congress exempted them. Unfortunately, not everything is exempt, because I've had a few guys say, well, I want to use the Elderly Home Detention Act, or program, but I understand it's up to the BOP, and then the Attorney General is the only one I can appeal to. Well, that happens to be in a different chapter of Title 18, and it's not exempted. So if you're the perfect elderly offender, you're 60 years old plus, you've done 2/3, you've got a spotless record, you got a nice home to go to, and they say no, you can appeal it to the Attorney General, and then you actually can bring an action under the APA. It's kind of nice, but unfortunately, the 500 miles, you just got to count on the BOP to do the right thing. Kind of a scary concept.
Yeah, that actually brings up a question that I had here, question number 7 on this list. So will 3621E RDAP time be deducted from 2/3 eligibility date for inmates over age 60, therefore making eligibility 2/3 minus RDAP credit? So it sounds like they're asking, can they get both of those?
Sure.
Okay, go ahead. Okay.
Yeah, they're saying, yeah, you have a 10-year sentence, you're going to get a year off for RDAP. So can you do 2/3 of 9 years and get the elderly offender? I had that question come up, and I took a careful look at the act. Congress was very careful the way it wrote that, and it didn't change here. This is the thing guys have trouble believing is that, the elderly offender home detention program is not new. Congress enacted it in 2007 as a 2-year pilot program, and it's in the Second Chance Act. I tell guys, you want to know what it's all about? You can go read the Second Chance Act, 34 U.S. Code, 60541G, and it lays everything out. All First Step did is make a few tweaks, like take the 10-year minimum out and change 75% to 66 2/3. But going back and reading that, it says that the 2/3 is of your sentence as imposed. And I read that to mean that they're going to look at what the court imposed, not what you might get off later. So okay. I'm telling guys that, you can hope all you want. I mean, God, we wouldn't have anything to do inside if we didn't hope, but don't count on it, because I think that if you got a 10-year sentence, you're going to do 6 2/3 years on it. And even if you have RDAP coming at the end, it's not going to help you reduce that 2/3.
So just to be super clear here, sounds like there's quite a bit of benefit to this. And to answer somebody's question before I forget real quick, I think Jace asked me earlier what the difference between a prison and a camp is on federal side anyway. They're both prisons. Typically one doesn't have a fence, one's low custody there's no perimeter. You can have jobs off the compound. It's really just a minor of security level. Does that answer your question, Jace? Camp, low, medium, penitentiary, they're all different level securities. So you're probably more than likely going to go to a camp. I did my time at a low. But I just got a question from a guy named Buddy Barrett. I was sentenced in February. Is there anything I can do to benefit from the First Step Act before I get sentenced? I am currently on home confinement. So I think he's asking, can any of his home confinement time, any of his pre-sentence, will any of that count towards anything First Step related?
No, it will not. The law has been clear for a long time that first, if you're on home confinement, if you're on pre-release custody at home, it doesn't count as jail time. And I've had guys try all sorts of things. One guy who was on very restrictive home confinement, where essentially had to call and get permission to go across the street. Didn't matter. Home is home, jail is jail. And the judge said, "Look, jail is different from home." And I think the judge is right, but he's not going to get any benefit for being on pre-release. Pre-sentencing home confinement, except he's not in jail. That alone is a benefit.
You get that nice little 3-point reduction on your custody level when you self-surrender if you keep yourself out of trouble.
Yeah.
So another question we just have here. This is a good question. This is a great question from, his name is I Vape Skittles. Okay. So Skittles is asking, who's going to be held liable for, like, right now, the bill's passed, it's not implemented yet, it's there. let's say somebody's supposed to be getting out within the next 3 to 6 months, that technically if they changed their dates right now, they would get out sooner. And what happens to people that do not benefit from it, that should have benefited from it? Is there any accountability, or is it's just got to wait until this thing's in effect?
Well, I'll start by telling you that there is an unpleasant provision in this act that I think is ambiguous, but can fairly be read to say that the 54 days, just like the program credits, don't start until about July 20th, 210 days after passage. I've had more than one guy tell me that. And in fact, one guy I've been working with who's in a halfway house in Chicago, and he calculated his extra 7 days a year would have put him out a month ago. He filed a 2241, a petition for habeas corpus, in the court last week, and the court's going to have a hearing tomorrow. I'm anxious to hear how that hearing goes, but he told me that he had talked to somebody who I know, I won't mention his name, but he is nationally known and pretty much up on this. He said he is sure that Congress intended that mean that the 54 days doesn't start until July 20th. That makes a certain amount of sense, because that would give DSCC down in Grand Prairie time to get everything set up and push the button on the right day. Although how Grand Prairie couldn't know this was coming baffles me. What happens if you were entitled under the law to get out and they don't give you the days? Well, you can always bring a Federal Tort Claim Act case and get whatever the federal government has some formula. You'll get so much a day for being in. It's not a lot. It's not like pulling a winning lottery ticket. But
it's almost going to be just as much of a pain in the ass for what you're actually going to get out of it, which is probably why most people don't follow through once they actually get released.
Yeah, I have a guy who now has the tort claim into region because he got held something like 25 days late before somebody looked and said, "Oh my God, this is wrong. You should have been out of here." And they showed him the door. But I thought it was pretty iffy even then that it was going to be worth that much for him. If it were like 10 days, yeah, forget it.
Just reading some of these questions here. So at what point can people start going directly back to the courts? It looked like there was something there on the compassionate release. If it gets denied within the BOP, they can then go directly to the court and get it overruled by the judge. Is that what I read?
Yes. Compassionate release has two provisions. Well, two ways to deal with it. If you apply to the BOP and you don't get an answer in 30 days, you go straight to court. If you get denied within the 30 days, you got to exhaust your BOP remedies, then you can go to court. But that still beats all those cases when you couldn't go to court. I spent a little time on the cancer floor at the medical center in Butner. I was in pretty good shape compared to a lot of those guys, and I worked on compassionate releases for more than one guy who died waiting for it. And in all the time, I only got one. Great guy. He was from Jalisco province in Mexico, or state, whatever they call it. Managed to get him out. We coordinated with ICE. They came and picked him up, took him straight to Raleigh-Durham Airport, and he flew home and got to spend 2 months with his family before he died. But, of course, one of the big complaints is people were dying while they were waiting. Now that's not going to be an issue. One would hope. It's still possible you could be denied by the BOP, and we all know how long exhausting remedies takes. Then you're talking about, 6 months perhaps, if you've got to go through 9, 10, and 11. I'm not sure you do, because if the warden turns you down, it seems to me you can go directly to 10 and then 11, but still, you're talking 3-4 months before you can go to court. The one interesting twist in compassionate release, though, is it used to be you had to die. In fact, the definition in the act is an elderly, terminally ill offender. But they have added a provision that if you are simply certified by the BOP doctor as somebody who needs assisted living or nursing home, you qualify. So, we're all terminally ill if you lay the timeline out long enough, but you don't have to actually be terminally ill to benefit from the thing. And I knew guys like that. Guys were wheelchairs. They were just, they had inmate care 24 hours a day and couldn't do anything. They can go to nursing homes. So that will work. There's another interesting twist in compassionate release. You're filing under 18 USC 3582 C1. C1 let you file it for extraordinary medical conditions, but also if you had rendered an extraordinary service. And it's kind of wide open what it is. I mean, I knew a guy up at Milan who his supervisor in Unicor fell over one day, heart stopped, and this guy did CPR until they could get somebody there, and they say the inmate saved his life. They put him in for a compassionate release or sentence reduction for saving a life. He didn't get it. But now, just like the terminally ill people, if you get put in for that and the BOP turns you down, you can go to your sentencing judge.
Wow.
I see that as opening a lot of opportunities, because when you go back to the sentencing judge may be able to sentence you without regard to restrictions he or she had before, like mandatory minimums.
Yeah. How much effect does this have on mandatory minimums?
Well, judge is wide open on a sentence reduction. Unlike a C2 reduction, when the sentencing commission drops the guidelines by 2 levels, there you're stuck with mandatory minimums because the sentencing commission says so. But not on a C1, a sentence reduction. I mean, you can go in with a 25-year mandatory minimum, come up with cancer after 3 or 4 years, and the judge could just say, okay, you're done, you go home.
So it doesn't affect minimum mandatories just in general. There's got to be a reason why the judge, like, for example, aggravated identity theft can this do anything with those type of minimum mandatories for somebody in a situation getting ready to get sentenced?
No, not at sentencing. You might later get to go in, but you've probably seen the stories or even read the transcripts of judges saying, I can't believe that I've got to give you all this time under the law, and if I could do it otherwise, I would. And it occurred to me that for judges like that, you probably remember Judge Gleason, Eastern District of New York, and what he did in the Holloway case back in 2014. I mean, this guy had, he had mandatory minimums. He had a bunch of extra time, but the judge didn't want to give it to him to begin with and had to. And the kid did an outstanding job in prison for a decade or so. So when he came in with a 2255, the judge called the U.S. attorney and kind of browbeat him into not opposing it, and it got granted. Well, that started a cottage industry, and there were all these paralegal firms out there saying, we'll file your Holloway motion. My guys calling me saying, how can I get a Holloway motion? I said, it's easy. Just make sure the judge loves you and your prosecutor loves you. If they both love you and they're willing to ignore the law, you're all set. Well, you know how many people fell in that category.
Not enough.
But not enough. But this strikes me as being a means for a judge who thinks he or she had to do too much to possibly find a way to do less.
So you offer okay, so let me tell people a little bit more about what you actually do, the way I found you. So you produce a weekly newsletter that I believe goes out every Monday, correct? Yeah,
every Monday morning.
Every Monday morning, you have a newsletter that goes out to anybody that has basically sent you a request in core links, or true links, the inmate email system. So you send out information similar to what we're discussing right now to keep people that are behind the fence or behind the wall informed with what rules, regulations, bills, things like that, correct?
Yeah.
And it looks like you also offer some additional services where you actually help people with pro se type motions. It sounds like you have a wherewithal of knowledge when it comes to filing different the BP forms. This is something that you've been doing for some time. Did this all come from your passion after you did your federal prison sentence?
Yes, absolutely. Back when I was in law school, I took crim law because we had to. I found it boring. I never took criminal procedure. thought after I took the bar, I'll never have to answer a criminal law question again in my life. Well, I was wrong. But it's a fascinating area. And I realized early on that, you go to court for a client and you lose a case, a tort case or a contract case, your client is out a bunch of money. But you lose a criminal case and your client loses liberty, and there's just no equating the two.
Not to get too off on that, but what do you think the problem is with the average federal attorney, whether it's a federal defender or a private attorney? Do you think they're on top of all of these gaps that exist?
Well, there are a few problems. I think that most of them are not compensated enough to do anything but plead somebody out. I remember a guy complaining, paid my lawyer $20,000 and all I got was his lousy plea. I said, for a mortgage fraud case? Man, in my case, I spent $250,000. Said the lawyer had 13,000 pages of discovery. And how do you read, digest, and know what's in those things without, on that kind of money? Lawyers got to eat too. That's the first problem. They don't get paid enough. And I'll have guys complain, well, I've got someone at the Federal Public Defender's Office. I say, well, thank your lucky stars, because those people usually know more about it than any appointed lawyer in the district. That's the first problem. Second problem is the system got so skewed with the Sentence Reform Act of 85. What gave us the guidelines? The Sentencing Reform Act put all the power in the hands of the prosecutors. And I've talked to federal judges who say, yeah, about 15% of our work is criminal law and we hate it. We can't wait to get back to civil so we can run our own courtroom instead of the U.S. attorney running the courtroom. But, the U.S. attorney controls the charging decisions. Charging decisions, control the mandatory minimums. And I mean, how many guys have gotten, stacked 924s, where, it's 5 years in the first one, 25 years in the second one, because he carried a gun to a drug deal today and he carried a gun the next day. And who wouldn't take a plea deal? So they take plea deals, and these guys just rack it up. It's an unfortunate system. When I was much younger, I thought, federal's got to be a better system, and these states are all messed up. Now I take my chances in a state system any day over a federal system.
As far as the type of sentence that you might receive, it seems like, because we do have clients that are on state side versus feds, and we really do see, usually we don't even see prison time for a lot of these guys. And then feds come in, pick it up, and it's almost a guarantee of going to prison.
But it's more than that too. I know that the guy who was prosecutor in my home county for about 20, 25 years, you could go to him and you could sit down and say, we got this, he's got 5 fourth-degree felony charges. That's just too much for what he did. And the prosecutor would listen, and there were times he would agree. He would do the fair thing, but you get a career assistant U.S. attorney, and they don't advance by cutting deals with defendants to make life easy for them.
Right.
And that's the problem.
Tom, for people that want to get your newsletter that are not incarcerated yet, do you also send it out to the average Joe?
No, I don't. But what I did, because there were a lot of people who wanted to see it, is every Sunday night at 10 o'clock, I put it up on my website. And it's right there. It said this week's newsletter, and they can click on it and see exactly what went to the inmates.
Okay. So right from your website from here, I'm going to post it again. Here you go, guys. Here's Tom's link again to his website. For those of you that want to get access to the newsletter, that either not in prison yet, or maybe you're not going, but you want to stay up on these current events. Here's his info one more time. There we go. Just shared that. So what about for some of these individuals, Tom, that maybe they need some additional help, or they've got some additional questions? They're looking for somebody to maybe create some pro se motions. Maybe they're getting ready to get released and they're getting kind of roadblocked from the Bureau of Prisons. Should they also contact you through your site? Is that something that you'd want people to reach out to you in regards to? That
would be just fine. I've got a contact form on there where you can fill in what you've got. I will tell you that the biggest complaint I hear from people is I call it the save your money for commissary speech. I have these guys say, hey, I want you to do this, that, and the other thing. I say, you can't do that. I said, well, can't you file? I said, sure, but you're going to lose. And I won't help you because I would feel wrong taking your money. You save that money for commissary. There's just a lot of things that can't be done. And if they can't be done, I'll tell you that. And, and then you can talk to somebody else. And I'm sure in the universe, you can find somebody who will do it if no one else than that guy sitting over in the law library all day typing motions.
Right.
They'll always do it for an ice cream.
Yeah. Or there's a lot of people tell you what you want to hear, especially when you sound desperate. And that's part of what we deal with on a regular basis. So guys, make sure you reach out to Tom. He's got his information on here because look, this guy's giving me so much information right here. And we're definitely going to be putting some of Tom's information and maybe putting some links on our website for those of you that need some additional content. We focus a lot on how you can reduce your sentence, qualifying for RDAP, preparing your personal narratives, character reference letters, making sure you understand how important it is to understand the effectiveness of a successful PSR interview, qualifying for second chance. We're going to be picking Tom's brain ridiculously over the next several months as we see this First Step Act kind of unfold, because so far, everywhere we turn has been just kind of go talk to this person, go talk to this person. Nobody has answers. So to get some of this from you, Tom, I think is going to be valuable information that people are going to take with them into the prison system. I kind of think you answered all of the questions. Let me see here. Does anybody have any questions that I missed in the room? If I missed a question, please repost your question. And Tom, if you have anything you want to add, feel free. I'm just reading through some of these here.
Yeah, I did see one. Apparently someone asked about people who had mandatory minimums of, people who had the life mandatory minimum for prior offenses under 841, the drug offense, got cut to 25 years, and people with 20 got cut to 15. And they were saying, if you got 25, is it going to change to 20? What can be done? Unfortunately, this was one of the provisions that Congress took retroactivity away from. There were 4 sentence reforms that got imported into First Step from the old Sentence Reform Corrections Act. One was safety valve. It's been expanded dramatically which is 18 USC 3553F for low-level drug offenders who didn't have a gun, who talk about what they did, plead guilty, and they weren't leaders. That expanded. There was the change in the mandatory life for if you had an 841 B1A offense. So let's say you had over 10 keys of cocaine and you had 3 priors, you had to get life. Well, now those people get 25 years. And there is nothing that is as depressing as me as to get an email from a guy who is doing life for it. And he says, well, how can I get it turned down? I said, you can't, because you're not eligible. And he says, it's not fair that I have to do life and the guy who comes along a year later doesn't have to. What can you say except, yeah, you're right. The one change that was retroactive, though, we all remember the Fair Sentencing Act in 2010. It used to be that crack cocaine was punished at a rate of 100 to 1. So 100 or 1 ounce of crack was equal to 100 ounces of powdered coke. And so consequently got a crack defendants getting incredible time. And of course, most crack defendants were minority. It became an issue early in the Obama administration, and Congress passed the Fair Sentencing Act. But to pass the Fair Sentencing Act, they had to give things back to some of the senators, and one was it wasn't retroactive. So anyone since 2010 got the benefit. But I've got all these guys from before 2010 who didn't get it. Well, with the change and the retroactivity of the Fair Sentencing Act, I'm amazed at there's an interplay of changing the statute and all those accumulated guideline reductions that they couldn't get. And some of these guys are having sentences cut in half. It's wonderful.
Wow.
Because to set your statute to, if you're a career offender, you know, they set your level at 34, 37 or some lesser amount, but it is based on the statutory maximum of your underlying offense. So a guy who had 28 grams of crack had a mandatory minimum of 5 years, it's 5 to 40, and he was getting, you know, he was getting dinged with like 34, level 34. Now 28 grams, the 28 grams is the bottom of the 5, and the range falls. So all of a sudden, he's not an 841 B1B, he's a B1C, and his prior doesn't count at all. So instead of having the mandatory minimum of 5 double to 10, he's got a 0 to 20 range. Wow. And that makes a big difference, because a lot of those guys were blocked by mandatory minimums from going lower. And all the career offenders were blocked from getting any benefit under the guidelines, and now they can. That's going to be the most fascinating area of sentence reduction to watch, all the interplay for the crack people.
So it gives a lot more control to the judge.
Yeah, the judge can decide. And I'll tell you, any of those guys who haven't filed yet, I'd say clean up your act, get rid of your cell phone, get rid of your vapes, start taking classes, clear conduct, rec, work hard, get good, because the judges look at all that.
And this is where pretrial, when people ask, like Buddy just asked again, I think he might have missed it. He wanted to know, is there any benefits that can come pre-sentence while he's on pretrial right now? And I would say really the only benefits are what Tom just explained, is any discretion the judge does have, what you do with your time right now on your day-to-day, and how you make yourself appear different the day of sentencing from the other 6 billion people that judge has already sentenced in a similar situation to you. How are you positioning yourself so you stand out in a positive light? And that's part of what we work on with people here. But we do have another question. And Buddy, if I didn't answer your question, feel free to shoot it back to me. We did have a question from Gifted Fingers. What happens to somebody if he gets a charge of conspiracy possession with intent to distribute K2, or known as spice? So these synthetic, like marijuana type drugs. Is that classified any different? Does this have any direct effect?
No, right now Congress is hot about the opioids, so that's why fentanyl, they're hot about meth and hot about heroin. But this one is just, as far as Congress considers it, a garden variety controlled substance. So that does not exclude him from getting any benefits under programming credits.
So he can't. So he can get the benefit, the program benefits with K2 and spice, which I thought. Yeah. Let me see. I think I missed a question. Are any of these bills going to improve the quality of the prison as far as staff, in addition to getting different programs? Are we going to see anything? Does this affect food, the way the staff treats people? Is there going to be anything else that slides in with this that we should be looking for?
No, not that I can see. BOP has the same wonderful dedicated staff it always had. I'm sure there is. I saw a news release today that several BOP employees have sued the government because they're required to work and they're not getting paid for it. So if anything, the BOP people are even happier now than they usually are. But no, I see nothing is going to make them any happier, except I suppose to the extent there is less inmates who better behaved. Who knows? It might rub off on them, might make their job easier. I do know that I've heard that camps that are attached to USPs and mediums are much nicer places than standalone camps, because the staff rotates over there from the medium or the USP, and they consider it like a 90-day vacation while they're over there. So they're taking it easy. But I don't know, because I did my time at a low and then the FMC, which was administrative, and got to know all sorts of interesting people there.
2 more questions. One of them is a question I have. But first, does a first step affect 5K1 in any shape, way, or form? I don't think so, but that's a question somebody has.
No, it does not. no, not even the retroactivity aspect of crack for anyone who might have a 5K1, they could still benefit. But no, no effect. If you're the kind of person who cooperates with the feds, get in line because there are a lot more out there than you'd ever think. In fact, for most inmates, I would never criticize them for cooperating with the feds because they face a terrible alternative if they don't. So do what you're going to do. It won't affect programming.
All right. So this question is going to keep repopping no matter how many times we answer it. So I'm going to try to this is a question from Lee Weimer. So when you talk about how much time somebody's actually going to serve, obviously there's many variables, but let's call it a perfect case scenario. Let's say somebody has a 75-month sentence. Best case scenario, good time, a year off for RDAP. From what you're telling me, they can really receive as much halfway house time as the BOP is willing to give them based on programming. So it's kind of hard to answer how much time they could get off because how would you compute that?
I'd compute it starting with 75 minus 12 being the 12 off for RDAP, and then take 85% of the number that's left. So that's going to be what, 63 months.
Well, it goes the other way around. So it's minus your good time, then they deduct the 12 months for RDAP.
Oh, okay. So they won't take it off the top. That's even better.
Yeah.
75 are going to take off about 11 months from that. It'd be about 64 at the 85%. I'm just doing that in my head. So then you take off the 12 for RDAP. Okay, 52 months. So you got 52 months. And let's say that you're able to program on 50 of them. The first month you're there, you're not going to get to do much except A&O, and it tapers down. But 50 months, and let's say you get 10 days a month, that's 500 days. So you might be able to get another year off actual time. And then the balance, which is going to be like 200 days, would be more halfway house, more home confinement. But still, then I've reduced it because if I've taken that off, it's kind of a sliding scale. You're not going to get to do programming all 50 months if you get another 12 off. But somewhere in there's a feeling. I would just say if I were going in and I got there on August 1, I would get in a program as soon as I could, just stay in it every month, just do them to do them. And as you probably remember in some of these classes, it's hard not to pass them. So pass them, do what minimal work they want done, and be happy with it. And if you are a low risk or a minimal risk, you're going to get 15 days a month. It's even sweeter.
All right, last question, guys. And if you have, if I didn't get to your question, please do me a favor. Once this video posts, put it in the comments. I've had a great time chatting with Tom, and I hope you'll come back and visit us again, Tom. Seems like people are really staying engaged with you because we can't answer everybody's question all at once. Last question I have, how does it affect a felon in possession of a firearm 922G?
Happily, it does not. The 922G, mere felon in possession, even a felon in possession with an ACCA, mandatory minimum 15 years, is eligible to take all the programming and get all the benefits anybody else can get.
So it will benefit them. Is that what you just said?
Yes, it will benefit. Unlike the 924,
Congress
didn't mess with felon in possession.
I'm posting my email on the link, guys. If you guys have any questions, here's my email. There you go. You got my email address. So Tom, I want to really appreciate you. I thank you for coming on and doing this with us today. Guys, again, Tom's information, if you haven't already gone over to his website, here it is one more time. He's got an amazing blog on there, which I'm going to yank at his shirt as many times as I need to let him, so we can start blogging some of our information over there and vice versa. I'd love to see Tom sharing his information over at RDAPDAN.com, because you are by far the first person I've spoken to that is given direct answers. It's not this trickery where what's the game called, where you zip around the cup and you can never find with the damn ball underneath it. So you've done an amazing job. I know, look, there's nothing more stressful than getting ready to go into prison for somebody that's never been in trouble before. We hear about people all the time going, you don't know how lucky you are that you're out on pretrial. The minute I got arrested, I got brought right into county. Yes, There is some truth to that, but at the same time, not knowing what's next and waiting for all of these things, that is a prison sentence within itself. That's why everybody goes, can I get credit for this? Because this is an extremely stressful period of time. So Tom, I really appreciate you joining us. Guys, go check out his site. He's also has some amazing services that he can help you guys with a lot of pro se type information. The man was a damn attorney, for God's sake, and he knows his stuff. And he's going to share some additional stories with us in the future, a little bit about his own prison experience. So Tom, do you have anything you want to leave anybody with that I didn't mention?
I think we've just scratched the surface, but it took us an hour to do it. So I'll be glad to come back. And yeah, I'm sure there are questions that'll come to people. Send them.
Awesome. Awesome. Guys, I thank you. As always, I'm RDAPDAN, Federal Prison Time Consulting. People helping people, community is method, one day at a time. And I will see you guys very, very soon. Peace.